Good morning, everyone, and welcome to our 2022 employee annual meeting. Again, we're virtual. I think this is the last. We still had some people who weren't quite comfortable all assembling in a big gathering. But I do think that next year we'll be back to a proper Cityscape get together. I want to introduce our executive team. So I think you know I'm Nick Berg. I'm the president of Cityscape. Also on the call, we have Robin Romo, our chief operating officer, Wayne Lee, our chief financial officer, Paul Mora, our vice president. Our Cityscape directors are Francis Serrano, Sergey Gorovsky, and Joanna Lamb. We have on the call Mark Owens, our president of Reliant. And yeah, that's our team. I can talk a little bit about 2022. So I was thinking about kind of what the theme for this year was. And I think really what it comes down to is that we made it mostly. So when I say that, if you think about the last couple years of the pandemic, there were a lot of businesses that didn't survive this period, unfortunately. You're talking about a lot of restaurants, a lot of fitness clubs, just a lot of retail. So I think just by function of our industry, but also because we were, continued to do good work and we're disciplined, we are still here. We survived it, which is, more than you can say for a lot of businesses. When I look back at my notes of what we talked about at last year's meeting, we were talking about masking indoors. We were talking about how just spent and exhausted everybody was because we had homeowners who were locked down for 2 years and were frustrated. Today, I think our communities are mostly back to normal. Certainly those COVID restrictions are in the rearview mirror for the most part. COVID's not gone, obviously, but we're not dealing with all the restrictions that we had before. And I think, just citywide, I'm seeing that, people are demanding that the city get its act together on a lot of different fronts. So I'm feeling really impressed with how far we've come. I feel relieved at where we are right now. And I think everybody should be, I am super proud of you all and how far we've come and where we are at this moment. So I think you guys should really be proud of yourselves at how you handled the last couple years. So I just want to thank you.
You're here, guys. Thank you.
Looking ahead, so again, I think we're in a really good place. Cityscape is. We're in a business that's relatively recession-proof. So whether we're going into a slowdown or something worse, we're actually in a pretty good place. And then, longer term, we are in a niche in the city where we serve HOAs. And the only kind of housing they're building anymore is going to be HOAs. And I don't know if you know this, but the state is mandating that San Francisco create a housing element, which is a plan. So they're saying the city must come up with a plan to build 82,000 units of housing in the next, I think it's 9 years. And if it doesn't, the state's gonna basically really ease the restrictions on construction. So one way or the other, we're gonna basically be, the one of the major managers of community associations, and a lot more opportunities and potential clients are going to be there. So I think this cityscape will continue to be a great place to be. Now, that doesn't mean we get to be complacent. We still have competitors. We still have clients that demand really high levels of service. So really what we need to do is keep our services at high quality, make sure we're giving white glove service to our residents, to our boards, continue to be indispensable at the communities that we have. And then those turn into referrals for new communities. So again, I just wanted to thank you guys all, and we'll move on to the next portion of the meeting, unless Robin or Paul or Wayne, do you guys want to add anything?
No, I just want to say that I am really excited to see the group. Year after year, we grow. It's good to see a bunch of new faces. The fact that we've all hung in there over these last 3 years during COVID is a feat in itself. I'm so happy to see that everyone is still with us. We're glad that you're here. We thank you again for hanging in there. We know it's been really tough, but we've gotten through this. We have a great niche business here. We're glad that you guys are all along for the ride. So good to see you all.
I actually echo exactly what Robin said. Thank you all for weathering the ride. I suspect, based on the way things are going, that it's going to get better. So I think that the hardest part has been done. And thank you all for surviving, because it has been a challenge. We all know this. People have been the biggest part of this whole thing. So I think we're coming up on the other side. So thank you all for doing this together. It's been a big deal.
I totally agree with everybody. I'll keep it short. We really appreciate what everybody has contributed. So thank you very much. Thank you.
All right. So with that, next, I want to introduce Courtney from Paychecks, who will do our annual harassment training. Courtney.
Hey, thanks, Nick. I appreciate that. Welcome, everybody. It's great to hear that the business is doing well, and exciting to see all of your faces. And some of you may have remembered me. I actually have done the on-site trainings for you in the past, where I got to hang out on the stage, which was really cool. Now I get to stare at a box, but that's all right. We'll try to make this as engaging as possible. Now, I normally use WebEx. I'm not normally Zoom, so I'm going to do my best to share my screen and see if this works for everybody. All right.
We see it.
Excellent. I love it. I love it. All right. So let me just figure out how to advance the slides. Can I do that from here? Oh yeah, there we go. I got it. Okay, we're good to go. All right, so welcome to your sexual harassment and abusive conduct prevention training today. So this training is for California managers, supervisors, and employees. But if there are any managers or supervisors out there who manage other individuals, you will need an additional hour of training. So Capri and I can touch base on that, and we can get you into that additional training. So as we go through the information today, do remember that the information in this seminar should not be considered legal or accounting advice, and it should not substitute for legal, accounting, or other professional advice where the facts and circumstances warrant. So this is really provided as a best practice training to give you some information about sexual harassment in the workplace, as well as abusive conduct. Okay, so as we go through the training today, we are going to be referencing a few of these major cases that really have altered how we look at sexual harassment in the workplace. So Meritor Savings Bank, we'll just run through these really quick, give you a little background on them and what they did for us. In 1986, Meritor Savings Bank versus Vinson. This was a landmark Supreme Court case at the federal level, and for the first time recognized sexual harassment as a violation of Title VII of the Civil Rights Act of 1964. So prior to 1986, sexual harassment wasn't technically against the law. Now, in On-Call versus Sundowner Offshore Services, this was a unanimous Supreme Court decision in 1998 that ruled that same-sex sexual harassment and discrimination is actionable under Title VII. So for the first time in 1998, same-sex sexual harassment was a violation of the law. In Harris versus Forklift Systems, this Supreme Court ruled that in a sexual harassment case, the plaintiff does not have to prove concrete psychological harm to establish a Title VII violation, effectively stating that a hostile work environment can be a violation of the law. So that happened in 1993. Now, in 1998, we had Farragher versus City of Boca Raton. Now, in this decision, the Supreme Court spelled out circumstances in which employers will be held liable for acts of sexual harassment carried out by their supervisory personnel. Now, the court ruled in this particular case at the federal level that the employer is strictly liable when the sexual harassment by a supervisor has culminated in a tangible employment action directed against the employee. So, for example, if the employee was terminated or demoted after rejecting a supervisor's sexual harassment advance. Now, the court further ruled that the employers are permitted to establish an affirmative defense to claim that they can show no tangible action was taken against the harassed employee, and they can avoid some amount of responsibility. And the most recent one here, Bostock versus Clayton County, Georgia in 2020. This was a landmark United States Supreme Court civil rights case in which the court held that Title VII of the Civil Rights Act of 1964 protects employees against discrimination because they are gay or transgender. The plaintiff, Gerald Bostock, was fired after he expressed interest in a gay softball league at work. The lower courts followed the 11th Circuit's past precedent that Title VII did not cover employment discrimination protection based on sexual orientation, but this case was consolidated with other similar cases from other circuits and escalated to the Supreme Court, which ruled in a 6-3 decision in favor of the employees. Now, when it comes to California, we've had some case law that has altered how we look at sexual harassment here as well. Now, in Lyle versus Warner Brothers Television Productions in 2006, this case is interesting to me because in this case, it ruled that the context of speech in the workplace environment is a determining factor as to whether it can be deemed sexually hostile. So in this particular case, the plaintiff, Lyle, was a writer's assistant on the TV show Friends. And he sued for sexual harassment because the show's writers engaged in a sexually overt banter and conduct in the workplace. Now, Warner Brothers argued that such speech was necessary to the creative process, and in light of the subject matter and storylines of the show, the court held that a plaintiff cannot maintain a sexual harassment claim based on sexually explicit speech when it is necessary to the creative process. We also had Hughes versus Pear in 2009. Now, in another case of sexually explicit speech, the court ruled that a few offensive but isolated comments made on one day during the course of a years-long professional relationship cannot be actionable as sexual harassment or intentional infliction of emotional distress. So in this case, the plaintiff, Suzanne, was the wife of Mark Hughes, who is the founder of Herbalife. After Mark died, he left a $350 million trust to their son, Alex. Now, Suzanne requested that the trustees release money for Alex's benefit. The trustees agreed to release half the money requested. A short time later, Suzanne alleged that the trustee called her and made sexual references and propositioned her, stating that in exchange, he would release an increased amount of money to her son. And the court held that even if Suzanne's account was truthful, these comments were isolated and could not form the basis of a sexual harassment claim. And lastly, the most important one on here, the State Department of Health Services versus Superior Court. This one was in 2003. And this one ruled that there is no Farragher defense under California law. So if you go back to the Farragher versus City of Boca Raton, this one that said employers could technically get out of responsibility for actions of their supervisors. But in California, that's not the case. So the Farragher defense can be used by employers to release them from liability for their employees' misconduct, but not their supervisors' misconduct. So it's important to remember that one as well, that federal law is a little bit different than state law here in California.
So Courtney, before you go on, I just want to make sure that everybody should have gotten in the mail a workbook. So it came in an envelope like this, and there is inside basically a harassment workbook. You want to, as we go through the rest of it, some of the answers are going to be are going to come up in the course of Courtney's presentation. So if you have it, go ahead and grab it now, and you'll want to work through it, because this is, you do have to turn this in. This is our evidence that you attended the mandatory harassment training.
Awesome. Thanks, Nick. I totally missed that part. I appreciate that. Thank you. Okay, so remember, here in California, we do have requirements that all employers of 5 or more employees must provide sexual harassment and abusive conduct training to their employees once every 2 years. So 1 hour for non-managerial employees and 2 hours for managerial employees. So here is your training today. So as we go through this training, do keep in mind that we're going to review quite a few things. So we're going to review harassment and protected classes, including sexual harassment and discrimination, who is protected by the law and who can be held liable under the law here in California. We'll discuss the different types of discrimination, including differential treatment, unintentional discrimination, and harassment. We'll also cover some key concepts and legal definitions of sexual harassment and explore the different types of sexual harassment, including quid pro quo and hostile work environment. Finally, as we finish up, we'll talk a little bit about abusive conduct, what to do if you have been harassed or witnessed harassment in the workplace, and remedies for victims of harassment. And finally, what to do if you feel that you've been retaliated against. So at this point, you may be asking yourself, what's the big deal? But unfortunately, harassment really is a serious matter that can affect not only the victim, but also the workplace environment. Unfortunately, subtle forms of harassment might not always be recognizable, and often people do not know how to handle it when it occurs. In fact, statistics show an alarming amount of harassment claims are filed each year by employees, resulting in staggering monetary benefits paid and tremendous costs incurred by their employers. Now, supervisors, managers, coworkers, and the company can all be held liable when it comes to sexual harassment in California. Now, sexual harassment is a form of employment discrimination that is based on sex or gender, including pregnancy, childbirth, or related medical conditions. Also, gender identity, gender expression, and sexual orientation. Now, because sexual harassment is a form of discrimination, the exact definition of unlawful discrimination may differ depending on the enforcing agencies and the courts. However, discrimination in employment may be broadly defined as treating a member of a protected class, which could be an employee, a client, an applicant, a resident, an unpaid intern, or a volunteer, or persons providing services pursuant to a contract in the workplace, less favorably than others because of that person's membership in that particular group. Now, the federal laws, the Equal Employment Opportunity Commission, the federal agency that oversees enforcement of some key federal anti-discrimination laws, including those prohibiting harassment, has identified several different protected classes. So things like age, but 40 or over, disability, genetic information, national origin, pregnancy, race, color, religion, sex, veteran status, as well as other protected classes. In fact, on June 15th of 2020, the U.S. Supreme Court ruled that federal law protects LGBTQ workers from employment discrimination. Ultimately, the courts held that Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, age, national origin, and sex, also extends to sexual orientation, gender identity, including transgender status. Now, specific updates will be made based on case law, which may alter how we interpret some of those laws. Now, here in California, we have taken all of those protected classes and we've added a few more. In fact, California has 17 different protected classes. And the Department of Fair Employment and Housing, or the DFEH, in California state agency that oversees enforcement of some key state anti-discrimination harassment laws, has identified these different protected classes. Now, California law prohibits harassment and discrimination in employment based on these. Now, Senate Bill 188 amended the Fair Employment and Housing Act, or FEHA, and expanded the definition of race to include traits historically associated with race, including but not limited to hair texture and protected hairstyles such as braids, locks, and twists. Now, discrimination claims may be filed with the EEOC or the DFEH or the DFEH. However, if the claim is for discrimination based on factors only protected at the state level under the California Fair Employment and Housing Act, or the employer does not meet the employee count threshold for coverage under federal law, the claim may only be filed under the DFEH. Now, the Fair Employment and Housing Council has issued some definitions when it comes to these different protected classes. Now, gender is an individual sex assigned at birth. Transgender, as a general term that refers to a person whose gender identity differs from the person's sex assigned at birth. Gender identity as the individual's individual understanding of and identification with their gender. Now, this may include male or female, a combination of male or female, neither male nor female, a gender different from the person's sex assigned at birth, or transgender. Now, gender expression is the external communication of a person's gender through feminine or masculine behaviors, clothing, or other characteristics. It's how I present myself to the world. Now, in 2003, California passed the Gender Non-Discrimination Act. That was Assembly Bill 196, which ensured that transgender and gender non-conforming people in California have legal protection from employment discrimination. In 2011, the expansion of the Gender Non-Discrimination Act further clarified that we are all protected from workplace discrimination based on our gender identity and expression. Now, when it comes to transgender rights in the workplace, let's review some practical guidance that help support a respectful work environment for LGBT employees. Now, this can include ensuring that you have updated policies that expressly prohibit harassment and discrimination, as well as retaliation on the basis of all protected characteristics, including gender identity, gender expression, or sexual orientation. So make sure you have read and reviewed your company's policies on this. Now, we should all refrain from gossip, rumors, or other discussions or speculations about an individual's sexual orientation or gender identities. Ensure that your company policy prohibits employees from engaging in any discriminatory conduct directed at employees because they associate with organizations that advocate for LGBT causes. And remember, employees should be addressed by their preferred name and pronoun. So when you refer to a person, you should use the name and pronoun consistent with that person's gender identity and expression. And if you're not sure, ask. Display the required posters at your work sites developed by the Department of Fair Employment and Housing regarding transgender rights in the workplace. And designate a human resources professional like Capri to ensure individuals' legal access to facilities, accommodate dress code issues, and help ensure respectful and proper communication with other employees about their transition process. So for more information, you can search transgender rights for the workplace or refer to the DFEH poster. Now, who is protected by the law here in California? So California employees, clients, applicants, unpaid interns and volunteers, or persons providing services pursuant to a contract in the workplace are all protected by the law in California. Now, likewise, who is liable under the law? In California, every employer or prospective employer is liable under the law. In addition, every person in the workplace, this includes managers, supervisors, subordinates, coworkers, if they are found liable for sexual harassment, they are personally liable for damages caused by their unlawful harassment. And an employer is strictly liable for unlawful harassment by its supervisors or agents. The individual harasser is personally liable for damages caused by his or her unlawful actions. Therefore, that means all of us are liable under California. So we all need to be aware of our behaviors in the workplace. All right. So here we go. Your first opportunity to fill out some of that workbook. So volunteers and unpaid interns are not protected against sexual harassment. True or false? Individuals can be held personally liable for sexual harassment. True or false? In California law identifies 17 protected classes for employment discrimination, harassment, and retaliation in the law. So I'll give you a minute to write down your answers. And here they are. So when it comes to sexual harassment, volunteers and unpaid interns are not protected. That answer is false. Volunteers and unpaid interns are protected against sexual harassment here in California. Individuals can be held personally liable for sexual harassment. That is true. Remember, individuals can be held liable for their own behaviors in the workplace. And California law identifies 17 specific protected basis classes for employment discrimination. That answer is true as well. Okay, so let's see, there we go. All right, so now under federal law, unlawful discrimination in employment involves treating an employee or applicant less favorably because of his or her membership in one or more protected classes. Now, there are several types of discrimination, including differential treatment, unintentional discrimination, and harassment. Now, non-discrimination principles and laws apply to all aspects of the employment relationship, working conditions in general, and a wide variety of employment decisions, including hiring, training, promotions, work assignments, transfers, compensation, layoffs, discipline, and/or termination, including constructive discharge. Now, working conditions generally refer to the workplace environment. It's important to provide a work environment where employees do not feel intimidated, unfairly treated, or segregated from others based on their membership in a protected class. So things like race, color, religion, sex, age, national origin, any of those 17 protected classes here in California. Now, when working conditions become so intolerable due to some unlawful reason, including harassment, that an employee feels compelled to resign, they may have a claim of constructive discharge. Now, constructive discharge is based on a reasonable person standard. That means a reasonable person would feel compelled to resign their employment rather than continue under those working conditions. Now, discrimination, as previously mentioned, can affect not only the victim, but also the workplace environment, leading to lost productivity, decreased morale, group conflict, damaged careers, and reputational risk to the company. So let's take a look at those different types of discrimination. Now, there is no legal requirement to treat all employees the same unless you have a written employment contract or you are a victim of illegal discrimination. Now, there is no requiring that all employees be treated equally other than the laws prohibiting discrimination. Now, differential treatment is referred to as disparate treatment. And this is when an employee when an employer treats an employee differently based on their, based on them being in a protected class. Now, when it comes to this, employers are obligated to prevent discrimination and intimidation among employees and should provide good working climate among their employees as well. So differential treatment is the intentional differential treatment between individuals based on membership in a protected class. Now, when it comes to unintentional discrimination occurs when you have an employment policy or procedure that, while it appears to be neutral on the surface, may actually have an unintentional effect of being discriminatory. So things like, when it comes to unintended discrimination, it's often based on unconscious bias, which includes stereotypes that a person may have about a group of people without that person even being aware. So if you have a hiring manager who may assume that an applicant with a physical disability is unable to perform the necessary functions of an open position. Now, due to what is likely the hiring manager's lack of knowledge about the applicant's disability and an assumption that the disability equals inability, the hiring manager may end up unintentionally discriminating against an otherwise qualified candidate. Now, lastly, we have harassment. Now, if someone is abusing, insulting, or otherwise harming you on a regular basis, it may be considered harassment. It can be annoying, sometimes cruel, or even illegal in some cases. Now, not all annoyances constitute harassment. Criminal harassment usually entails intentionally targeting someone with behavior that is meant to scare, torment, or terrorize them. Harassment charges can range from a misdemeanor to a high-level felony charge. So let's go through a quick scenario. All right. So Tom is a model employee who is relied upon by his manager, Sue, to mentor and train new employees. The last 3 times a promotional opportunity has come up, Tom applied, but the promotion was given to one of the female employees Tom has trained. Now, in this example, Tom may feel like he's being discriminated against in the promotion process because he's male. And on this basis, he may have the grounds for a gender discrimination case. But can it be considered harassment? Now, based on the information provided, Tom may have that intentional discrimination claim against his manager for overlooking his talents based on gender, but the facts stated do not allege any specific harassing behaviors toward Tom because of his gender. Now, coming up, we'll review the definitions of harassment and we'll provide some details on what type of behaviors could constitute harassment. All right, get out your workbooks. Okay, so true or false? California FEHA prohibits discrimination and harassment based on several protected characteristics, in addition to the protected characteristics under federal law. And what does FEHA stand for? Federal Employment and Housing Act, Fair Employment and Housing Act, Federal Employer and Housing Act, or Fair Employer and Housing Act? I'll give you a minute to answer those questions. All right. So true is the first one. So California FEHA prohibits discrimination and harassment based on several protected classes in addition to those at the federal level. And then FEHA stands for California Fair Employment and Housing Act. Okay, so which of the following is a potential negative impact of workplace harassment? Decreased morale, lost productivity, tarnished company reputation, or all of these? And true or false? Both employees and applicants are protected under anti-discrimination laws enforced by the EEOC. Remember, that is the federal level. All right, got those answers in? All right, so of course, the first one is all of these, and the second one is true. So the EEOC actually does protect employees as well as applicants, but the federal law doesn't protect clients, residents, volunteers, interns. Those are all protected at the state level. Okay, so which term best describes a situation where an employee is a victim of discrimination, including harassment, and the conditions are so bad that they are compelled to resign? This one is constructive discharge. So remember, constructive discharge is based on a reasonable person standard. That is, would a reasonable person feel compelled to resign their employment rather than continue working under those intolerable working conditions? All right, now we're going to jump into a little bit more on harassment. So while we've talked about discrimination in general, next let's take a closer look at unlawful harassment. Now, unlawful harassment is unwelcome conduct that's based on a protected class when enduring the offensive conduct becomes a condition of continued employment, or the conduct is so severe and pervasive as it creates a work environment that a reasonable person would consider intimidating, hostile, or abusive. Okay, so now it's important to remember when it comes to harassment, standards of conduct and behavior that could be considered harassment may be adjusted in the future based on the claims received and the cases heard by the courts. Early on, we talked about how those different case laws really affect how we interpret the laws that were already in place. So even as recently as 2020, the Civil Rights Act of 1964 actually was modified a little bit, and the interpretation of that was modified. So while illegal harassment is a form of discrimination, not all discrimination claims are necessarily considered harassment. So now if we think back to our example of Tom, he was a model employee who is relied upon by his manager to mentor and train new employees. Now, could this scenario also be considered harassment? Probably not. Now, Tom may have an intentional discrimination claim against his manager for overlooking his talents based on his gender, but the facts stated do not allege any specific harassing behavior towards Tom because of his gender. So now let's take a little closer look at sexual harassment. And due to the prevalence of allegations of sexual harassment, we'll cover this topic in a bit more detail. But remember, claims of harassment can be based on membership in any protected group. Now, the EEOC has provided some guidelines in defining what sexual harassment is. Sexual harassment is unwelcome sexual advances, requests for sexual favors, or any other verbal or physical conduct of a sexual nature when the conduct explicitly or implicitly affects the individual's employment, if it unreasonably interferes with an individual's work performance, or if it creates an intimidating, hostile, or offensive work environment. Now, when it comes to California, we got to do things a little bit differently, but pretty similar here. So FEHA defines sexual harassment as harassment based on sex or of a sexual nature, gender identity, gender expression, or sexual orientation, gender harassment, and harassment based on pregnancy, childbirth, or related medical conditions. Now, the definition of sexual harassment can include many forms of offensive behavior, including same-sex sexual harassment. Now, types of sexual harassment can include unwanted sexual advances, offering employment benefits in exchange for sexual favors, actual or threatened retaliation, leering or making sexual gestures or displaying sexually suggestive objects, pictures, cartoons, or posters, making or using derogatory comments, slurs, or jokes of a sexual nature, and sexual comments including graphic comments about an individual's body, sexually degrading words used to describe an individual, or suggestive or obscene letters, notes, or invitations, and lastly, physical touching or assault, as well as impeding or blocking movement. Now, a claim of sexual harassment under FEHA does not need to be motivated by sexual desire. Sometimes sexual harassment situations are not motivated by sexual interest at all. It could be a situation without sexual advances, but rather a victim's identity or sexual identity is attacked by derogatory or insulting comments or gestures that are sexual in nature. Or it could simply involve sexually graphic or suggestive objects, pictures, or language in the person's environment. Now, when it comes to some key concepts that I do want you to remember as we go through this, sexual harassment can occur between individuals of the same sex. It has been settled law for some time, especially in California, that same-sex sexual harassment is actionable under FEHA. Remember, sexual desire is not required. Recent legislation clarified existing law by expressly stating that sexually harassing conduct need not be motivated by sexual desire. Now, this legislation, which was Senate Bill 292, actually was passed to reject the contrary decision from 2011. And lastly, adverse employment action is not required in order for sexual harassment to exist. The complainant does not have to have a tangible economic loss or other adverse employment action. The crux of the harassment claim is that the assault was the assault on the complainant's personal sense of dignity and well-being in the workplace. Back to your workbooks. All right, true or false, sexual desire is a key element in any claim of sexual harassment. And an employee can file a claim of sexual harassment even if the supervisor took no adverse employment action such as termination, failure to hire, or demotion against the employee. All right, there's your answers. So remember, sexual desire is not a key element of sexual harassment in the workplace. And then when it comes to an employee filing a claim of harassment, this answer is true. So an employee can file a claim of sexual harassment even if the supervisor took no adverse employment action against the employee. Okay. All right, so now we're going to cover a little bit more on the different types of sexual harassment in the workplace. So first, we have a quick scenario. So let's take a look at an example of quid pro quo sexual harassment. Michael asks his administrative assistant, Christian, to stay late to work on a special project. When they are alone, Michael makes sexual advances towards Christian. Christian tells him he has a boyfriend and he's not interested. But Michael continues to pressure Christian, telling him that he can kiss his career goodbye if he won't comply with his requests. Now, because the manager in this case appears to be conditioning his assistant's employment opportunities on accepting his sexual advances, this is probably a pretty good example of quid pro quo sexual harassment. So now quid pro quo, this is Latin for this, for that. You do this for me, I do that for you. So quid pro quo is when sexual favors are demanded in return for a tangible employment benefit. For example, a promotion, or when a victim is threatened with termination or demotion or some other detrimental impact to their employment because they failed to meet the sexual request. Now, this type of sexual harassment generally involves a supervisor, a manager, or a person in a position of authority or perceived authority. And the essence of a quid pro quo sexual harassment claim is that a supervisor relies on his or her apparent or actual authority to extort sexual favors from the employee. Now, this threat could be expressed or implied. So remember Tom from our earlier example? What if he got an email from his manager stating that he would only get the promotion if he went out on a date with her? Now, conditioning a promotion in such a manner would probably constitute an unlawful sexual harassment claim. Okay, so let's take a look at this situation. So Blake is a sole proprietor of Acme Company. He has decided to expand and compete for state contracts. Blake hires Jack, an independent contractor, to install a computer network. Now, Blake threatens to sue Jack for breach of contract unless Jack agrees to engage in sexual activity. Now, which of the following statements is true? Jack can't sue Blake because he's an independent contractor. Jack can't sue Blake because Acme Company has fewer than 5 employees. Jack can't sue Blake because he's a man. Or Jack can sue Blake for quid pro quo sexual harassment. Got your answers filled in? Right answer here is D. So Jack can sue Blake for quid pro quo sexual harassment. Okay, so who is typically the perpetrator of quid pro quo harassment? Remember this for that. And true or false, quid pro quo sexual harassment can be based on a single event. I'll give you a minute to write down your answers. All right, so when it comes to the perpetrator for quid pro quo sexual harassment, remember a manager, a supervisor, someone in a position of authority or perceived authority can be the perpetrator of quid pro quo sexual harassment. And quid pro quo sexual harassment can be based on a single event. This is true. So if under the circumstances, the request for favors or threats of harm would be enough to convince a reasonable person that a protected individual would suffer for failing to comply, the unlawful harassment can be based on one event. So now let's take a look at the other type of sexual harassment. We have hostile work environment. So a hostile work environment occurs when an employee is forced to work in a hostile, intimidating, or offensive work environment, usually because they're subjected to unwelcome gender-based sexual conduct that is pervasive or severe enough to alter the terms or condition of the person's employment. Now, the more severe the conduct, the less frequently it likely has to occur for the conduct to create a hostile work environment. Unwelcome verbal or physical conduct that's based on gender can also be the basis for a sexual harassment claim. Remember, hostile work environment can be based on any protected class, including race, religion, age, disability, or sexual orientation. So now hostile work environment harassment is characterized by conduct which is sufficiently severe or pervasive and alters the terms or employment conditions to the extent that it creates a hostile or abusive work environment. Now, guidance also indicates that in determining whether the conduct rises to the level, it should be evaluated from the reasonable person standing in the shoes of the victim. So reasonable person is a person who with an ordinary degree of reason, prudence, care, foresight, or intelligence, whose conduct, conclusion, or expectation in relation to a particular circumstance or fact is used as an objective standard by which to measure or determine something. Now, when it comes to some hostile work environments, some other considerations are the nature of the conduct, the frequency of the conduct, the period of time over which it occurred, whether the conduct was physically threatening or humiliating, and the extent to which the conduct unreasonably interfered with the employee's work performance. So remember, we do want to refer back to the Harris versus Forklift systems, which was the case law that determined hostile work environment is a violation of the law. Now, when it comes to hostile work environment, does it have to be caused by a manager? No. So this can be caused by anyone in the workplace. Co-workers, supervisors, clients, independent contractors, anyone in the workplace can cause a hostile work environment. So let's take an example, take a look at an example of a hostile work environment. Megan is a customer service rep at a wholesale distributor. Jim, an employee of one of her company's biggest customers, comes into the distribution center weekly to pick up orders. When he does, he always waits for Megan to be available so she can wait on him. For some time, Megan hasn't thought anything of her interactions with Jim. They might joke or flirt a little when he comes in, but that's really all it was. But recently, Jim asked Megan out on a date. Megan said no, telling Jim she is in a committed relationship and not interested in dating anyone else. But Jim isn't taking no for an answer. Every week, he asks her if she's ready to go out with him. Megan is tired of having to tell Jim no, and although she has mentioned her concern to her supervisor, she doesn't want to keep complaining since Jim's company is a very important customer. Now, can this example be considered sexual harassment? The answer is yes. This example may be considered unlawful sexual harassment due to Jim's unrelenting, unwanted advances. Megan is entitled to be protected from unlawful harassment, regardless of the fact that Jim is not a fellow employee, but rather a customer. So the courts have recognized 3 different types of hostile work environment here in California. They have conduct that is directed at the claimant, conduct that is directed at others, and widespread sexual favoritism. Now, harassing conduct can include unwanted sexual advances, and it can be verbal, visual, or physical. So verbal harassing conduct can include foul language or obscene language, derogatory comments, explicit discussions about sexual activities, or comments of other people's physical attributes. Visual harassing conduct can include leering, scaring, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffiti, or posters, or sending graphic emails or text messages or jokes, even if it's off work time. And physical harassing conduct can include kissing, hugging, grabbing, impeding, or blocking movement, as well as assault. Okay. So you and Chris have been good friends for 3 years. You've dated on several occasions. Last week, Chris was promoted to director. Chris is not your direct supervisor, but the head of your division. Chris stops by your office and asks you to dinner. Concerned about how having dinner with the new director may look, you decline. Chris leans over your desk and states that if you want to be promoted to supervisor, it's in your best interest to go to dinner. Now, is this situation quid pro quo or hostile work environment? This one is quid pro quo. So remember, when sexual favors are demanded in return for a tangible job benefit, in this example, a promotion, it is evident that Chris expects you to meet his requests in return for that tangible job benefit. So this is quid pro quo sexual harassment. All right, your work area is a back office operation and it's pretty hectic. Men and women both refer to each other using derogatory terms. Now, one of your coworkers visits a website every morning and shouts out a joke of the day, which is always of a sexual nature. Now, most of the workers participate, but if you seem uncomfortable, is this situation quid pro quo or hostile work environment? This one is hostile work environment. So remember, the work environment is sufficiently riddled with conduct of a sexual nature that is severe and pervasive enough that a reasonable person may consider it intimidating, hostile, or abusive. Okay, so true or false? To prove hostile work environment sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. And true or false, to prove hostile work environment, the complaining party must show that they were subjected to unwanted sexual attention that was both severe and pervasive. All right, the correct answer to the first one is true. So the complaining party does not need to show that they suffered an adverse employment action in order to prove hostile work environment sexual harassment. And remember, the next one is false. To prove hostile work environment, the complaining party does not have to show that they were subjected to unwanted sexual attention that was both severe and pervasive. So when it comes to some conduct that could be considered unlawful, remember, since we can all be held liable for sexual harassment, do keep in mind, these are some examples of conduct that could be considered unlawful sexual harassment here in California. Now, this is not an all-inclusive list. But sexual offensive jokes, pictures, or sexual comments, rude treatment of women or men because of their gender, including same-sex sexual harassment, unwanted invitations, notes, or flirtations, gossip, rumors, or other discussions or speculations of an employee's sexual orientation or gender identity, sex as an implied condition of promotion, sexual harassment after a breakup of a relationship between employees. Now remember, in any of these situations, the harassment can come from a coworker, a customer, a vendor, a client, a resident, an applicant, an unpaid intern or volunteer, or a person providing services pursuant to a contract in the workplace. Now, some examples of nonverbal sexual harassment can include things like emails with sexually suggestive messages or pornographic pictures, physical harassment, including touching, massaging, invasion of personal space or physical assault, or leering or elevator eyes. Now, when it comes to harassment, in addition to whether the conduct is reasonably interpreted as offensive, it is not the intent of the harasser that counts, but rather the impact that that behavior has on the recipient. So keep that in mind. It is not the intent, but the impact. All right, true or false? A male employee can be the victim of sexual harassment. And true or false? Unlawful harassment can occur where both individuals are of the same sex. True. So both men and women are protected from sexual harassment, and unlawful harassment can occur in same-sex situations here in California. So both of these answers are true. So now let's take a look at an example of what might not constitute sexual harassment. So Pete and Angela work together in the finance department, and they both enjoy listening to the same genre of music. Pete asks Angela if she'd like to go with him to a concert. Angela thanks Pete for the invitation, but tells him she's not interested in going out with him. So assuming Pete does not continue to pursue Angela, simply asking her out on a date once does not likely constitute unlawful sexual harassment. So, yes or no, does sexual desire have to be the underlying reason for sexual harassment? And is asking a coworker out on a date considered sexual harassment? Hopefully your recall is pretty good on both of these. They're both no. So remember, sexual desire does not have to be the underlying reason for harassment. Harassment may be a way of intentionally or unintentionally expressing dominance or power over another person. Sexual harassment may be a bullying tactic that is used by someone to get what they want. For example, if we think back to the scenario where the manager requires his administrative assistant to work late, the manager is likely acting on more than just sexual desire and is using his position of power to get his way. Also, simply asking someone out on a date is not considered sexual harassment, but remember, no means no. All right, let's cover a little bit about abusive conduct. Now, Assembly Bill 253 defines abusive conduct as malicious conduct of an employer or an employee in the workplace that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interests. Now, abusive conduct can be verbal or physical and may include things like repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, or epithets, or the gratuitous sabotage or undermining of an employee's work performance. Now, abusive conduct can be exhibited by an employee, a manager, a coworker, an applicant, an unpaid intern, volunteer, or person providing services pursuant to a contract in a workplace. Now, a single act often does not constitute abusive conduct unless it is especially severe or egregious. Abusive conduct is not against the law unless it rises to the level of unlawful discrimination or harassment. Abusive conduct, by definition, may not be based on a protected class, and it may not rise to the level of unlawful discrimination. So you may be thinking, how are abusive conduct different from harassment? Well, abusive conduct and harassment can seem suspiciously similar. However, harassment is a form of discrimination and is defined as unwelcome conduct that is based on a protected class. Abusive conduct, as mentioned earlier, is generally described as hostile, offensive, or malicious behaviors that are intended to humiliate, threaten, or intimidate someone. The biggest difference is that unlawful harassment is based on a protected class. Abusive conduct may not be. So even though harassment and abusive conduct may be different by definition, it's important to be able to recognize both. It is your responsibility as an employee, manager, or supervisor to prevent both types of conduct in your work environment and address them when they are reported. Okay, so what is the Latin phrase that is used when a person of authority demands sexual favors in return for promotion or other job-related benefit? And true or false, under California state law, an employee, applicant, unpaid intern, volunteer, persons providing services pursuant to a contract in the workplace can create a hostile work environment. Awesome. So the first one is quid pro quo. Remember, Latin, this for that. And true, all of those individuals can create a hostile work environment here in California. So how does the Fair Employment and Housing Council define gender identity? Is this a person's internal understanding of and identification with a gender? Is it an individual's sex assigned at birth? a person's gender-related appearance, behavior, or all of these? This one's tricky. This is a person's internal understanding of and identification with a gender. So now let's talk a little bit about what we should do and our responsibilities as employees. So sometimes confronting the alleged harasser is all it will take to get the unwelcome behavior to stop. Now, the alleged harasser may not be aware how uncomfortable you are with their behavior. And if you're not comfortable confronting the individual, then you should report the situation to the person designated in your harassment policies. That's Capri. So they will be responding to complaints of harassment in accordance with your company procedures. Remember, the company can't stop harassment in the workplace if they are unaware of these situations. So it's a responsibility of all of us to make sure that we report those. So follow these steps and refer to your company's non-harassment policy. First and foremost, immediately tell the alleged harasser that the behavior is unacceptable and unwelcome. If you are unable to confront the alleged harasser, or if the unwelcome behavior continues, you should report the incident to Capri. So make sure that you look at your company's policies. It contains internal complaint processes that are available to you. Now, if you witness harassment in the workplace, anyone who witnesses or becomes aware of potential instances of sexual harassment should report it to a supervisor, manager, or designee. Now, it can be uncomfortable and scary, but it's important to tell coworkers that's not okay when you are uncomfortable about harassment happening in front of you. Remember, it's everyone's responsibility to look out for each other. It's unlawful for an employer to retaliate against you for reporting suspected sexual harassment or assisting in any investigation. Now, when it comes to bystander intervention, here's some definitions for you. So in addition to reporting harassment, if you witness harassment, there are some things that you can do. So when it comes to sexual harassment, victims and witnesses can be afraid of speaking out for fear of retribution. However, it's critical for you to learn and recognize sexual harassment and intervene when you can, because you may be able to disrupt sexual harassment and improve the work environment. So let's look at some definitions. A bystander is a person who witnesses sexual harassment. A victim is a person who has been sexually harassed, and an ally is a person who believes sexual harassment is wrong, supports a victim in sexual harassment, and takes action to stop the harassment. I think I got some feedback. Make sure you guys are on mute, please. All right, and bystanders can be victims too. So harassment affects coworkers as well. So sexual harassment not only can harm the target, but it can also harm the working environment. So it can exist in the workplace culture. So all employees have a right to work in a harassment-free environment. Now, some options that you have as a bystander, you can confront the harasser and say, stop. Often, if the behavior is unacceptable, bystanders should be firm, clear, and concise. Sometimes it's all it takes to stop harassment or abusive conduct from continuing. Be an ally to the victim and let them know that you are there to support them. Document what you see. Bystanders can help victims by recording audio or video on your phone, taking photos, or writing a note or email and describing what happened. Documenting the harassment may be helpful to the victim, but it's not required for the victim to have a claim. Support the victim if they need it, and interrupt or distract the harasser. Oftentimes, distracting the individual is a great way to stop the harassment from continuing. And follow up with the victim. Once the situation is passed, bystanders can check in and support the victim and offer help or support. But remember, we all have a responsibility of keeping harassment out of our workplace. So here are some best practices and things that I want you to consider when you are at work. Remember, there's rules to the workplace, just like there's rules to the golf course or the basketball court, there's rules to the workplace. So we should avoid engaging in any behavior that could be considered harassment. Use good judgment and common sense in dealing with others. Even if you don't find such conduct personally offensive, some of your coworkers might. So follow your company policies. Avoid engaging in behavior that can be in any way considered demeaning, embarrassing, or offensive to others. If another employee informs you that something you have said or done has made them feel uncomfortable, do not repeat that behavior. And correct any harassment situations by acting in a prompt, fair, and confidential manner. Ask the harasser to stop or report any instances of harassment to one of the people indicated in your policies. This includes harassment that is directed towards you or a coworker. And be aware of your behavior towards any employee who may have complained of harassment. Remember, we're part of a team and we must be supportive of each other in all aspects of work. And the fact that someone files a complaint of harassment does not mean that they are disloyal to the team. It means that they need and deserve to work in a positive work environment. Retaliation for any complaint of harassment is illegal and strictly prohibited. And remember, your company is committed to protecting the confidentiality of employees reporting suspected violations of unlawful harassment to the extent possible. So if you're involved in a harassment investigation, your supervisor will explain your responsibility as a part of the investigation. Now, when it comes to remedies of sexual harassment, employees, applicants, unpaid interns, volunteers, or persons providing services pursuant to a contract in the workplace who feel that they've been subjected to harassment in the workplace can take the following steps to remedy the situation. First and foremost, we want you to come forward and talk to us. So talk to Capri if you feel that you're a victim of harassment in the workplace. You can also contact the Equal Employment Opportunity Commission or the DFEH. Now, there are some remedies under the applicable laws available to protected individuals, including injunctive relief, such as training, development, or changes to policies or procedures. Economic damages, such as reimbursement for lost wages, benefits, medical expenses, or job search expenses, as well as non-economic damages, hiring or reinstatement, reasonable accommodation, recovery of attorney's fees, compensatory damages, punitive damages, which are a punishment, and liquidated damages equal to the amount of back pay awarded. Now, in California, complaints must be filed with the EOC, that's the federal agency, within 180 days of the day the discrimination took place. With the DFEH, we have a little bit longer period of time, and claims can be filed within 3 years of the alleged violation. Now, keep in mind, you do have some additional resources for victims of abusive conduct, including the Employee Assistance Program, and Capri can get you more information on that. Employee handbook policies as well, including your EEO statement and non-harassment policy, open door policy, employee relations philosophy, or policy against workplace violence. We also have management and employee training that is available to employees. Now, when it comes to retaliation, Title VII of the Civil Rights Act forbids retaliation when it comes to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, or any other term or condition of employment. It is illegal to retaliate against people, whether it be applicants or employees, because they filed a charge of discrimination, because they complained to their employer or other covered entity about discrimination, or because they participated in employment discrimination proceedings, such as an investigation or lawsuit. Now, types of retaliation may include, but are not limited to, dismissal or demotion, transfer or change of responsibilities without justification, negative evaluation, and decrease in pay rate. So if an employee feels that they are being retaliated against, they should report it immediately to Capri. So remember, there is a no retaliation provision, which can be found within your policies as well. Okay, so a few more questions for you. So which of the following might be awarded as a remedy to a victim of employment discrimination? Back pay, training, policy changes, or all of these? And how long from the date of alleged violation of the California Fair Employment and Housing Act may an employee file a complaint with the California Department of Fair Employment and Housing? All right, the first answer is all of these. The second one is 3 years. We have a 3-year statute of limitations here in California. True or false? If you observe harassment taking place in the workplace, it's best to let the people involved resolve it between themselves. It's really none of your business. True or false? If you honestly do not intend to offend anyone, your behavior cannot be considered harassment. And if someone lets you know that your behavior makes them uncomfortable, you should stop that behavior immediately and not engage in that behavior again. Okay, so number one, false. As witnesses, it is our business. We all have a responsibility for keeping harassment out of the workplace, so we should address those things. The second one, if you can honestly don't intend to offend anyone, your behavior cannot be considered harassment. That one's false. Remember, it is not the intent of the harasser that matters, but the impact that that behavior has on the recipient. And if someone lets you know your behavior makes them uncomfortable, you should stop it immediately. Absolutely true. So be aware of how your actions affect others in the workplace. Fill in the blank. If an employee witnesses potential harassment situation, the individual should approach the alleged harasser. The individual should try and console the employee being harassed. The individual must report the situation as directed in the company's non-harassment policy or problem-solving process, or the individual should do nothing and mind their own business. Now, when it's C, remember, you are responsible for reporting the situation. The company can't make changes if they don't know that it exists. All right, so remember, as we went through the training today, we all have a responsibility to keep harassment out of our workplace. That involves treating others with dignity and respect in the workplace. So we did cover today harassment and protected classes, who is protected by the law, and that we all can be held liable for the law. Also, the different types of discrimination, some key concepts and legal definitions when it comes to harassment in the workplace, the different types of sexual harassment, abusive conduct, what you should do in the event that you have been harassed or witnessed harassment, as well as remedies for victims of harassment, the investigation process that Capri will be handling, and retaliation. So if you have any final questions or comments, we do have an email box that can be addressed. You can email that one directly, or I'll stick around for a little while if anybody has any additional questions. But thank you for attending part 1 of your sexual harassment and abusive conduct prevention training today, and I hope you all enjoy the rest of your day. Nick, I'll turn it back over to you.
All right, thank you so much, Courtney. So yeah, everybody, we take our culture very seriously, and that we want to provide a work environment that is free from harassment. So again, Capri is a designated person if something needs to be reported, or any member of the executive team.